Out to the legal landscape, our legal analyst, attorney Dan Adams, joins us every Monday, breaking down the biggest cases happening across Wisconsin and the country. Dan, it's good to see you. Let's start with this case of Maxwell Anderson. Our Zoe Henry has been reporting this morning on today's status conference for Anderson. It's happening today, 1 week before he goes on trial for the murder of Shade Robinson. Can you break down what happens during a status conference and what both sides here are really preparing for a high-profile case like this?
Sure. On any case that's going to trial, you usually have a status conference. It's a checking in with the court to pound out any issues that might be outstanding that can be addressed before the jury panel is summoned down and the trial starts in earnest. So in this case, we know that there was some lab reports that were outstanding. That's obviously something the state needs to have in its control and to pass over to the defense before trial. We also know that the parties are going to work on what's called a jury questionnaire. We know that this is such a high-profile case that they're not just going to want to query the jury panel as a whole with oral questions. They're going to present them with a paper questionnaire to try to get their hands around who's on that jury panel veneer. Then they're going to pound out any other issues. Are there any other discovery issues outstanding? Are there any witness issues? In a case this size, we could have dozens of witnesses. The state and the defense are going to have to posit to the court whether they have subpoenaed these people and they have them prepared to come over this 2-week trial. And again, any other issues that the parties may think may arise and will delay the trial need to be told to the judge today. Otherwise, the wheels go up next week and we're going to expect a 2-week trial.
And that status conference set to start at 1:30 this afternoon with jury selection 1 week from today. Dan, while we have you, I do want to get your take on some big news late last month from the Illinois Supreme Court overturning actor Jussie Smollett's conviction in his alleged hate crime hoax.
Yeah, this is interesting because usually the concept of double jeopardy, that's the constitutional right to not be prosecuted twice for the same crime, happens when somebody is actually takes a plea of guilty or is found guilty at trial. In this case, the Illinois Supreme Court said, no, double jeopardy basically attached when Smollett was given a plea deal before his case went through the process. They essentially dropped the charges. But he paid $10,000. He did some community service. So what the Supreme Court of Illinois said was, hey, you guys made a bargain, meaning the state, you have to abide by it. So his case has been dismissed. This is the same concept that got Bill Cosby out of prison a couple years ago. There was a previous prosecutor, made a deal that a subsequent prosecutor didn't like. But the courts have said your hands are tied. Once you make a deal with the defendant, double jeopardy attaches.
Pretty interesting. Dan, it's always great to have your insight and analysis. We'll see you next Monday for more of The Legal Landscape.